Welcome, everyone. I see a lot of you have joined us for the last panel standing, or sitting, I should say. Wonderful. Please take your seats, and I'll introduce myself. My name is Anna Berlet, and I work as a professor of privacy and data protection law at the Open Universiteit. And I'll be moderating this session on Are Two Rights Better? Explaining decision making under the GDPR and the AI Act. And with me today are four, although you see three, but four wonderful speakers. And I'll introduce them firstly. On the right-hand side at the very end, we have Charlotte Barrault. She has been working at the AI unit of the CNIL since 2023, where she contributes to the preparation and implementation of the AI Act, ensuring its alignment with, amongst other things, the GDPR missions. And what is really interesting about this panel in general is the diversity in terms of the backgrounds as well. And Charlotte's background is in cognitive science, so not a lawyer by heart, maybe now, but at least a cognitive scientist by training as well, focusing on the hybrid decision making in compliance with the GDPR. Next to Charlotte is Luca Tussoni, who works as a lawyer at Schut in Norway. Previously working in both academia, as you may know, and at the Norwegian Data Protection Authority, where he served as a specialist legal director in the International Affairs Department, and has written numerous works on Article 22 of the GDPR, as well as on the right to object, for example, in the GDPR. And next to me is Andreas Heusermann, who works as an assistant professor at the Open Universiteit as well. And next to that, he's also a lawyer at the I should say it properly, the Blackstone Westbrook in the Netherlands as well. And he has a PhD in AI and law, and specifically on automated decision making, and has written a very interesting paper specifically on the topic we're discussing today as well, the right to explanation in both the GDPR and the AI Act. And I'm not just saying that because I work with him, but I think you all should read the paper as well afterwards. And online, joining us online is, oh, there she is, wonderful, hey, is Francesca Palmiotto, who works as an assistant professor of law at IE University. And her research is, and again, signaling the different backgrounds as well, on the impact of AI, artificial intelligence, on fundamental rights in criminal justice. And she has also worked at many different other places, also in Berlin, and has been a member of the Board of Trustees at Fair Trials Europe. So, and therefore we had a pre-discussion and we said two rights on explaining. We should maybe think of a little bit more, although we do have a right on automated decision-making in the LED as well, and of course in the EU GDPR. And we saw this in the previous session as well, in Article 9 in the Platform Works Directive as well. But we'll focus on the right to explanation under the GDPR and on the AI Act. And to start us off, we have three parts basically. First, the what, the when, and the why. So basically the scoping of the rights. Then the how, how to make this actually work in practice. What does this require? And thirdly, okay, so what does it actually do and does it actually work? So starting us off, Francesca, if I may give you the word, could you please elaborate a little bit on the triggering conditions of when an automated decision-making is actually automated?
Thank you so much. And can you just confirm that you can hear me?
Yes, we can.
Well, great, fantastic. Good afternoon, everyone. I'm really sorry I can't be present with you. But yes, let's start from the zero questions probably, which is when do we have a right to an explanation? So here I will mainly focus on GDPR and AI Act, even if the poor little sister of the GDPR, the Law Enforcement Directive, could also be interesting because there for sure the right on explanation is much weaker, has a weaker legal grounding than in the other two legal sources. So starting with the GDPR, let's start by saying here that the right on explanation in the GDPR is more of a safeguard, or at least that's how I see it. In cases where automated decision-making is not prohibited, but exceptionally allowed, that's one of the safeguards that also needs to be present. And here we have some conditions. There must be an individual decision, which likely excludes group decisions, decision with legal or significant effects, and it must be solely automated. And this is surely the most contended, say, criterion or triggering condition, which I will go back to in a second. And then we have the AI Act, which in order to obtain explanation, the affected individual must, of course, be affected by decision, which is taken by an AI system. So unlike data protection, here we have a regulation that, of course, is not technologically neutral. It must be an AI system, of course, unlike in the GDPR, which can be, let's say, more traditional software used for decision-making. But it must also be high risk under Annex 3, so standalone AI systems. Now, going back to the GDPR, and then I will connect to the AI Act as well, I believe we still have a definitional problem. So if the right on explanation is triggered when the decision is individual and solely automated, which is exceptionally allowed because it's not prohibited, then we need to have a clear definition of what solely automated means. And in that sense, even with Shufa more recently, the landmark case by the Court of Justice, I believe we still don't have very strong interpretive guidance of when is a decision solely automated. And why I'm saying this, because the approach of the court in the Shufa case, which was a credit scoring case, was extremely context-based. So in that situation, the court analyzed whether the decision could be considered solely automated ex post. We had a decision already. There was also a complex case because we had different subjects. This is what also Ruben Means and Michael Veal some years ago defined in their amazing paper on Article 22. This is what an administrative lawyer could call composite decision-making, so very complex decision-making processes where you have different actors, right? And then you have a final decision and who is accountable for that final decision, right? But in that case, there was, allow me to say, easy to see it ex post. Of course, the credit scoring had an impact, a huge influence. It was decisive for the actual decision of denying the credit. So it was kind of easy to say, this is within the scope of Article 22. But what about the other cases? We still don't know. And I think the core challenge here is really to find a definition that allows us to know in advance. We need to know in advance. We need to know before to trigger the right to an explanation, but also to trigger, most importantly, the prohibition. And I think we still don't know that. Now, connecting to the AI Act, we have a similar problem. Why? Because again, the right to an explanation is triggered when you have a high-risk AI system that is standalone, so Annex 3. Now, you may say, well, what does this have to do with solely automated decision-making? Well, it does, because in the exceptions to the risk classification in Article 6, so this would be Article 6, Paragraph 3, at some point it tells us there is a presumption of high risk in those areas covered by the annex, so biometric identification, risk assessment, et cetera. We can name many of them, hiring tools, firing tools, et cetera. But then there are some exclusions. For example, when the system does not materially influence the outcome of decision-making. See, we are back to this idea of decision-making. And for example, this could be a procedural task, this could be a preparatory task, these are examples. But again, to me, it's very unclear. And it goes back to this idea of automated decision-making, like in the GDPR. So when it's not relevant or impactful, then it's outside of the scope of the AI Act, and we don't have the right to an explanation. Now, the message that I want to convey is that we have a huge definitional problem from a legal perspective to trigger these rights. to trigger the prohibition in data protection law, but also to trigger, of course, the high risk regime in the AI Act. And I think we have kind of a dilemma. We need there are different options or pathways that we could look at. One is to say, let's adopt a very coherent, let's say, definition of automated decision-making that can operate uniformly across the AI Act and the GDPR in the case where we agree that both explanations kind of fulfill the same purpose, and so they should be uniform. If we agree on that, we will see also throughout this panel which direction we will take. So I'm really looking forward also to hear from Andreas. But of course, if instead we have different purposes, then maybe we need two different definitions, because then we have different purposes of the rights that are triggered. Or, and I'm a strong advocate for the second option, to be a bit more strict on the definition of automated decision-making that is useful for the prohibition. So we have a definition that is only useful for triggering the prohibition, but then we must be more generous, more open, and less stringent with the definition that we need in order to trigger the right to an explanation. And I would advocate for this approach. And there are many reasons for this. Empirical evidence, we have tons of empirical evidence that shows we have a bias, we have automation bias. So, a decision when you have an automated system we cannot fully understand when humans retain discretion in that sense because of this phenomenon. But I will give you a very, very boring doctrinal argument, which is that when we talk about explanation in the GDPR, it says at least in the cases of Article 22, at least in those cases. So why not in others when, even if the decision is not solely automated, an individual deserves to have an explanation about why their legal sphere has been impacted. So I would advocate for the second, and I hope that throughout this panel, we can surely have more ideas on how to, approach this.
Thank you very much. And I think that really ties in, as you mentioned, the question of how to explain the specific right and the scoping of it really depends on what you're trying to achieve. So the purpose of the right and of the different rights, and maybe whether they overlap or are quite different. And for that, I'd love to give the floor to Andreas, if you could mention.
So you want me to elaborate on the purposes of the rights, or more on the
scoping?
The scoping, yeah. So if we compare the scope of these two rights, we actually detect both similarities and differences. I think Francesca already pointed to that. To start off, obviously, with the similarities, Francesca also mentioned it. Let's say the regulatory target is in both times individual decision making, and on both regimes, these decisions need to relate to natural persons. And then if we look a bit further also in terms of the impact or the degree of impact, there are at least comparable, so legal effects or similarly significant effects, although the AI Act is slightly more specific and also requires, in addition to the GDPR, an adverse effect on health, safety, or fundamental rights. So I think that's already one of the differences, although a slight difference. And then I will turn to the differences in terms of, what is actually covered in terms of, the output. So according to the GDPR, it only relates to personal data. And the AI Act actually refers to the output from a high-risk AI system. And I think this output can be both personal and non-personal data. And then I think concerning the technology used, also Francesca elaborated a bit on that. I think we can argue that the GDPR is technology neutral in the sense that, it covers all kinds of decision making as long as it's automated. That means really simple if-then rules, old school algorithms to really advanced AI systems as well. compared to the AI Act, which actually only refers to high-risk systems mentioned in Annex 3, with the exceptions to those relating to critical infrastructure. And there, I think, in terms of the last point, namely the degree of automation, I kind of, to some extent, disagree with Francesca, because the GDPR is clearly solely automated. So in this sense, no human involvement, or at least no meaningful human involvement. And in this regard, I think that the AI Act is neutral. So it doesn't matter whether it's completely automated, partially automated. And then I would also like to go back to Francesco's point with the derogations according to Article 6, paragraph 3, because I would argue that the mere fact that the decision is based on an output from an AI system materially influences the decision making. So in this sense, the derogations, according to Article 6, paragraph 3, are in my view not really likely to apply in this case. And then if we read a bit further, it's also clearly stated that the derogation doesn't apply if it involves profiling. And I think in many cases, the output of an AI system will to some extent relate to profiling. And I will now turn to the content of these rights. Under the AI Act, deployers need to explain the role of the AI system in the decision-making procedure and the main elements of the decision. Conversely, the GDPR, the meaningful logic involved in automated decision-making obliges, at least according to the European Court of Justice, to explain the procedures and principles applied to obtain a specific decision. And then, in this sense, the European Court of Justice also emphasized that data subject need to be able to learn which personal data has been used in what way in the ultimate decision in question. So also here, we see some similarities. Also here, for instance, both provisions relate to the procedures. But in my view, the AI Act is slightly more specific and actually also unveils something about causality, because deployers need actually to explain what the role was of the AI system. That actually means how did I think in this context, the output of the AI system, how did it influence the decision, and what were the main elements of the decision? And based on that, so I think we could infer some causal information, and that information might actually help data subjects to better understand the decision. And I think in terms of the ruling of the Dun & Bradstreet ruling, I think we will have a bit more elaborate discussion.
That's a really nice segue, as if we have discussed this earlier. Because indeed, mentioned already the Dun & Bradstreet case, and earlier also mentioned by Francesca, the Schufa case. Those were the only and the first two cases we actually had on Article 22 of the GDPR. Even though we had the right and the preceding right under the directive already since 1995, so which was really amazing that it took this long for at least the European courts. We saw in the member states they caught up a little bit earlier, that we had rulings on the matter. And the Dun & Bradstreet case specifically, of course, you're all well aware, provided more information on how to explain what this right to explanation actually entails. So I was wondering if, Charlotte, if you could go a little bit more into the role or how Dun & Bradstreet actually influences the discussion and the interpretation of the right itself, of what the right to an explanation entails, and the technical limitations, for example, there as well.
Thank you. Do you hear me? So I will start from the main case law already mentioned by Andreas and Francesca. So what does it say? Basically, what we keep from Dun & Bradstreet is that an explanation for the data subject is only meaningful when it's actionable. And what does it mean to be actionable? There are, to us, 3 layers. The first one is that the data subject should be informed of the very existence of an automated decision the data subject shall be informed that there is automated processing, and this is the a priori information we already know from GDPR Article 13 and 14. So this is the necessary condition. People should be aware of the fact that their data are processed automatically. Otherwise, they cannot exercise their rights. But here, the information, the main information in a GDPR point of view is only global. It can only concern the global logic because the output doesn't exist a priori. So the second element, and this is where Dun & Bradstreet is really interesting, is that what shall we expect as a data subject after the processing? What is a meaningful and individual explanation? And here Dun & Bradstreet tell us that the explanation shall be specific, so it regards the individual and not only the whole and general logic. Secondly, it has to be accurate. And thirdly, it has to be useful. And what does it mean to be useful in that sense? It's the purpose of the explanation is actually that the subject can act on it. The subject can either challenge inaccuracies, challenge the decision itself, and use opposition right, 22 paragraph 3. Or if it's not possible to oppose the decision, at least the data subject can know what to change, what should the subject change to obtain a different outcome. Eventually, change of behavior, change of life. But to take a very trivial example, if I am denied a loan, it's not useful for me to know that I am classified high risk. I want to know if this is unpayment, my debt ratio, or an unstable outcome, or even if I have a family and children, I want to know what I should change. So this is I think the main element of Dun & Bradstreet. The information has to be useful for me, so I know what to change. But there is a very important condition, a third condition for the information, the explanation to be actionable. The last element is the effectiveness, the technical effectiveness of the right to explanation. That is to say, the designer has to know, has to understand the process. It seems trivial, and it is possible in case of symbolic algorithms, but we know it's very complicated for deep learning. And we know that there are a lot of algorithms that operate in what we say, how we call them black boxes. So even the designer or the controller doesn't really know in a very specific case why the outcome is the outcome, because there are implicitly learned parameters. There are thousands and thousands of factors and parameters. So this is I would say, the change of point of view from explicit rule design system to an optimization system, and where mathematically we cannot always know how we obtain certain outputs. So it's very challenging. There is a whole field in computer science, explainable AI, which has emerged, but at the CNIL we are a bit, we do not really buy it completely, because sometimes this can be used as fair washing, as you know, so you can manipulate the technique and you can show, you can hide biases, you can do a bit of cooking with that. So we tend to be very careful with explainable AI. It doesn't mean that every deep learning algorithm is not licit, is not legal, but it's not always the key to provide some very complicated explanation afterward that no one can check. So what we argue is that at the current state of art, some explainability techniques are not sufficiently reliable or mature to ensure the effective exercise of the right. And this is a position which is shared by a Supreme Court in France. This is a decision dated from 2018 regarding French national law about administrative access to decision. And the French Constitutional Council considered that we should be particularly careful using some types of algorithms in administrative decision. And I quote them, On this basis, it held that algorithms capable of autonomously modifying their own decision rules without supervision and validation by the controller cannot serve as the sole basis for an individual administrative decision. So here we go back to the notion of automated administrative decision. And to conclude, I would like to say to us there is also an overlap between the definition of automated decision and the notion of technical limitation, the intrinsic opacity of some algorithms. The problem is not only for the explanation and the data subject, the problem is also for the supervision and the meaningfulness of the human intervention. If the person supposed to act on an algorithm doesn't understand how they obtain such output, how could they intervene meaningfully? So here, decisions could be always automated if people do not understand them.
So you mean not only for the right to explanation, but also the legitimacy of actually using the specific. Would you go that far?
Yes, I would say for the qualification of fully automated decision.
Yeah, yeah.
Because we can do the parallel with Shufa. When individuals are given a score, a percentage, it's not even possible to challenge it because how do we know that it's not 30%, it's 35%? So I think it's also it is linked to the definition of automated decision.
Yeah, wonderful. And that really ties in with the next question, which relates to, we have the GDPR, which covers both, which can cover regular old algorithms that we're used to, and also the deep learning ones, they can also fall under it, but then they might also qualify as high risk AI systems. And then we have the AI Act, which also has a right to explanation. The question then becomes, why is it necessary to have such a specific right in the AI Act? What is the added benefit in that sense if we already have something covered under the GDPR? And I was wondering, Andreas, if I might give you the word.
So perhaps you can also elaborate on the interaction on the two rights to start with. So I think as a general principle, both the GDPR and the AI Act coexist. That means they apply in parallel, I would say. With some exceptions, obviously, not really relevant in this context, but specifically concerning the right to explanation, there might indeed be scenarios where both rights are triggered. That's something we can imagine. And I think in this case, if we look at Article 86, Paragraph 3, in these cases, I think the GDPR will prevail. But I mean, yeah, we can have a long discussion about this, but I think this is quite clear. But then I think the question is more, okay, that doesn't necessarily make the right to explanation under the AI Act obsolete. Because I think, as I've pointed out, there are indeed similarities and differences, but the scope is certainly not identical. So I think, why is it needed? I think at least two reasons. The first one is that, in my view, the right to explanation under the AI Act actually provides complementary protection compared to the GDPR, because it also covers decisions that are not solely automated. And then I think also scoping related, if we look at the Article 86, what is the purpose of this right? Then recital 171, I have it in my notes, actually says it aims to enable individuals to enforce their fundamental rights. And we all know that the fundamental right to data protection is only one of the fundamental rights covered in the Charter. So in this sense, I think the AI Act is way broader. And also maybe relatedly, what is the purpose of the right to explanation under the GDPR? I think mainly for data subjects to enforce their rights, particularly under the GDPR, namely the safeguards, to obtain human intervention, to contest the decision, and to express their own point of view. And then obviously also broader data subject rights. But then I think in this context, what is also relevant is what is the purpose of Article 22 GDPR. So I think this is something that GDPR has clarified, or at least enlightened me concerning the goal of Article 22. And it actually ruled that Article 22 aims to protect individuals or data subjects from the specific risk associated with the automated processing of personal data. And I think this is a bit, the link, so it mainly relates to the processing of data, personal data, aka fundamental right to data protection. In this sense, I think the right to explanation under the AI Act is broader, it covers fundamental rights, and also if you look at the required impact, it also concerns safety and health.
So they can both exist equally and complement one another even. That's wonderful. That works really well. But then the question is, does this also happen in practice? Of course, we don't have the AI Act for quite some time. We haven't had it for that long. But we have had Article 22 for quite some time, and even the preceding right under the directive. We don't necessarily see a lot of use in practice. And Luca, I was wondering if I might give you the word to maybe elaborate a bit on the academic awareness of the right and the practical awareness.
Sure. I think we have seen in practice what the academic, what's the, let's say, the status of the academic debates. Even among the panelists today, we don't have entire alignment on how we read these rights and these provisions. And as you might be aware, there has been a long-standing debate on the existence itself of the right to explanation under the GDPR. Finally, the Court of Justice has kind of settled that debate and concluded that such a right exists. But of course, not everyone is an academic in this world, and most importantly, the people that should benefit from these rights to make it meaningful, should first and foremost being aware of it. We have seen little enforcement or little case law around this. I think we have started to see more and more of these cases, in particular in the Netherlands, so probably you two guys can talk a bit more about these cases. There are another few cases in different member states, but overall, and I can also speak out of my direct experience, when I was working for a European DPA, I've basically never seen a complaint about Article 22 or the right to explanation, maybe one or two occasionally. So in practice, authorities have either decided to act on their own initiative on these issues, or because of collective action led by NGOs or let's say workers' rights organization that have decided to initiate some strategic case or trigger enforcement in this area. But so far we've seen very little use of these rights. And that's the problem that is also connected to how complex these provisions are, and it's not really easy to understand how to interpret them, the scope of these rights, their interplay, not only between, let's say, the AI Act and the GDPR, but let's say also the interplay with other rights, because I think the right to an explanation is not an absolute right under the GDPR, for example, and the protection of trade secrets, for example, is a common counter-argument when this right to an explanation is invoked by data subject. So I think more clarity around the relationship between these rights would be needed to make sure that these rights are actually more used in practice. But I think the twist in the plot in all this is linked to the use of AI for writing complaints. I think recently, for example, the Norwegian Data Protection Authority has experienced a 300% increase in the number of complaints they receive. And that's because people have started to use AI to write complaints. So it will be interesting also to see how AI will be used to make use of these rights against automated decision making. So it's a tricky twist of the plot, but I think that eventually will play a big role in how these rights are exercised in practice. And maybe a final point I wanted to make is that data subject not only need to be aware of the existence of the right and exercise it, but the complexity of all this is that they also need to identify the right avenue or the right authority to try and exercise the right. And then if we take into account what you said about the relationship between these two rights, it becomes complicated for data subjects to identify the relevant data protection authority or market surveillance authority to exercise the right, which adds an additional procedural complexity to all this and will probably in a way slow down the actual practical use of these rights. So this is also something we need to monitor and see what will be the actual impact of the existence of the rights in Europe.
Yeah, absolutely. And please, if I may ask Francesca to continue on this topic, why do you think people do not challenge the decisions if they're solely automated or made by high-risk AI systems? Could you perhaps, in specific topics that you've researched or looked at, elaborate a tiny bit on this as well, continuing on what Luca said earlier?
Me and my co-author, Daria Outspool, we wrote a paper on strategic litigation against automated decision-making systems. So we're focused more on civil society organizations challenging these tools, starting by the premise that we have very little individual complaints in specific areas like migration, which is where we focused, broadly intended, migration and security, so to speak, where there is a huge power imbalance. So we have very vulnerable data subjects. And I could say the same also with regard to more my field, which is law enforcement, criminal justice, where again, you have huge power imbalances. So why we don't have any complaints coming from these areas? Well, what our research showed is, again, little awareness, huge barriers on the side from these data subjects. And most importantly, they are focused on challenging the decision per se, rather than making a complaint under data protection law. So that's also the problem of interaction between, say, migration law, criminal law, criminal procedural law in this sense, and data protection. So imagine being a suspect of a crime. Would you actually challenge certain decisions that are taken on you and going against that authority because you're bringing a complaint to a data protection authority? Probably I would advise my client against that, or I would think about it strategically. Because of this power imbalance, because of this fear, because you're still in a relationship with that authority in this process. So that's part of the problem that we have seen. My intuition, and I must admit, this is an intuition, it's my hypothesis, I'm working on this, is to understand also whether these authorities, what we would call deployers now, or data controllers, depending on which regulation we are applying, may most of the time say, wait a second, this is not solely automated decision. It's not. There is full meaningful intervention by the human, so there is no prohibition, and so you're not actually entitled to that right to an explanation. So in this sense, that I think is also part of the problem, which goes back to the definitional issue that I presented the idea. And that's why I'm strongly trying to support the idea that we need to broaden the triggering condition of the right to an explanation, at least under the GDPR. Yeah.
And if I may counteract this a tiny bit, is this really specific to Article 22 of the GDPR? Because the problems you discussed, the power imbalance, strategic reasons for not using it, etc., definitional issues, are these not all hampering any of the rights that data subjects have? Or is this really specific to this particular right? And this is not necessarily only a question to you, but also to the rest of the panelists. Is this really different from, say, a right to access or asking rectification or erasure? Are you not also there hampered by similar issues of looking at who the controller is and your relationship in relation to the controller? We still have discussions on the right of access, the scoping of it, whether or not you agree. We still have issues on what type of restrictions apply, etc. And the scoping of, for example, the impact of the rights of the controller themselves, for example, mentioned earlier, trade secret, etc. Is there, yeah, of course.
It's a guess. I don't have data about this, but working at the French National Data Protection, I think what we see about complaints is that people begin to get very much aware of confidentiality threats. Where are my data going? Are they going in the United States? Where is my health data stocked in my phone, for instance? But I would guess that automated decision, it's very different from the rest of the GDPR, even for us. It's kind of a window to enforce things that are not necessarily linked to confidentiality only. And so I would guess that if there is a problem regarding automated decision, people are not thinking of the CNIL, they're not thinking of the DPA. They're going to ask the controller once, twice. They're gonna, I don't know, post something on Twitter, on LinkedIn. I don't know, but I don't think people associate data protection with the autonomy and the sovereignty of human judgment in decision. But it's only a guess.
I would share your view on this, and I think that's confirmed by the practice, because if we think about how these rights have been used in practice, we've seen more court cases, meaning that people decided not to maybe complain to a data protection authority, but trigger like a trial in court, which is, let's say, a more typical avenue to defend labor rights. And so maybe that's also connected with the perception you were just describing. People tend to forget that maybe data protection authorities could also be involved, but try to resort to the alternative way of defending their rights.
And maybe this is also a good link to kind of go to what are the remedies actually if controllers under the GDPR don't comply with the right to explanation. I think data subjects have quite a nice, quite some options. So they could submit a complaint with the supervisory authority. They could even challenge the decision of the supervisory authority, like a judicial remedy, and they have a judicial remedy against the controller. And if we look at the AI Act, this is quite different. So they could, in principle, an individual could lodge a complaint with the market surveillance authority, but that's it. And what strikes me the most, or maybe I missed something, but what strikes me the most is actually deployers of AI systems that don't comply with the right to explanation. They don't even need to fear a fine, because if we look at provisions relating to fines, I don't see Article 86 mentioned there. Or maybe I missed something, I don't know.
No, I think another interesting point on this, on the avenues for enforcing the right, I think what we will need to watch out carefully is whether at some point the Court of Justice will interpret Article 85 on the right to lodge a complaint with the market surveillance authority, because in principle we don't know, but the wording would suggest that the obligation of those authorities to look at the complaint is less stringent than the obligation that data protection authorities have under Article 57 of the GDPR, which the Court of Justice has interpreted quite strictly. But I don't think that we can exclude up front that the Court of Justice would look at Article 85 of the AI Act and say, well, actually maybe that the fact that the complaint shall be handled in accordance with national procedural rules means, in fact, that these two obligations are quite similar. We don't know it yet, but I think that's an area where I think there will be room for the court to clarify how much, under an obligation, market surveillance authority are to look at every single complaint they will receive. That's an open question, but I don't know if any of the panelists
and I was
have
wondering as
input
well
on
what
this.
then the consequences are, because if you only look at the complaint, you don't provide a remedy to the individual who has complained, but rather you look at whether or not you should go and look at whether the AI system in place actually went through all the steps and maybe requires a new change as well. So the remedy there isn't individual, it's rather related to the product itself rather than the complaint of the effects it had on the individual, or at least my interpretation. But I think that really allows us to go to the room and see if there's any questions from the room to any of our panelists on the topic, or any clarifications or disagreements, etc. Do you all? Yes, I see one or two hands. I see multiple hands. Okay, let's do two questions at a time, because more than that. Yes. I see the people, the technicians, wait. Oh yeah, go on.
Hi.
Yes.
So you talked about Shufa case and Article 22 GDPR, and I want to talk about Article 14 of AI Act as well. So Article 22 says not to be subjected to automated decision making. Article 14 says that when you deploy high-risk AI systems, you need to have human oversight. So that means you put a person behind the machine who finally takes the decision. But in the Shufa, the court ultimately held that you put a person behind the machine and the person believes the machine and takes the decision, then it is not an informed or complete decision. It's an artificially created decision. So my main question to you is that how do you define that informed decision? What are the ingredients of that informed and reasoned decision would be? Thank you.
Yeah, thank you also for a great panel. I learned a lot. From what I gather from what everybody was saying is that the complaint after decision, it's useful maybe, but what we actually would need is understand how a decision will be made before it is made. And then I was wondering, because we have transparency, ex-ante transparency obligation in both the GDPR and the AI Act, and I know the one in GDPR mentioned something about automated decision making. I'm not that well versed in the AI Act, but I think there's something there too. Could they offer this to us, something before, for us all, I mean, before a decision is made, that we can understand what will happen to us? Because I feel that seems an important ingredient that actually later can also help you in your complaint.
Yeah. Hang on with the questions. I think two at a time makes it a little bit easier for us to remember them. Is there anyone who would like to tackle the first specific question on Article 14? Yeah? Oh, yeah. Francesca, maybe?
Yes, I think I would just like to reiterate also what Charlotte says, which is, again, we need an explanation also for who is taking the decision. Otherwise, how can a person take a decision without understanding how to use the machine and retain discretion? Meaning, if I disagree with what the machine recommendation is, I can disregard that. And in order to disagree with the machine, I need to understand how the machine works. So that's also the double function, I think, of the explanation, also for having human oversight. But I agree with what was said. When is a decision informed, or when is a decision not solely, meaning we have sufficient oversight? It's super difficult to know it ex ante. That's something that I am really struggling with. We can only know it ex post right now, or we take a different approach where we say in these cases is, of course, we don't care that much whether it's solely, whether we have sufficient human oversight. What's the benchmark? When can we say this is sufficiently informed? It's very difficult in that sense. So That's why I am, let's say, strong. I'm resisting towards this idea that it must be solely automated to have an explanation. We must have an explanation regardless, also for the human to give human oversight. So that would be my take, but.
Yeah, and if I may add to that, I think Article 14 doesn't require you to have human oversight. It requires you to have in the AI system the ability to that the user of the AI system actually has the option for human oversight. It doesn't require the deployer themselves to arrange this as well, but it has to arrange the option that it is possible. And whether or not it's then used is irrespective of, or that depends on the system itself. And the second question by Laura, is there anyone who would like to tackle that one? Yeah, Luca?
Well, I think, Laura, as you rightly pointed out, I think ex ante transparency is as important as ex post transparency. And like yourself, I'm more familiar with the rules in the GDPR, and I would say that there it's quite clear that there's room for both, and both, let's say, Article 13, 14, and 15 do make reference to some degree of transparency around these issues, and I think all these provisions have a role to play ex ante and ex post. Whether the AI Act complements this, I would say that the approach is quite similar, but I'm not sure whether it adds much to what we already have under the GDPR. And we in this panel, we agreed we're not going to make this panel into a digital omnibus panel, so we're not going to talk about it. But of course, everything that we are discussing today, is up for discussion again once we will know the fate, in particular, of Article 22 in the digital omnibus proposal, because that can also, in a way, change and make irrelevant some of the things we have said today.
Yeah, maybe I could add to Laura's point also that maybe Article 13 and 14 GDPR could actually create something and ex ante like more, because now we know it's meaningful logic, meaningful information about the logic involved. Now the Court of Justice has interpreted it with regard to specific decisions. So I think, or I would wish that there will be case law relating to this provision, so 13 and 14, and how they kind of complement each other as well.
And can I ask something, but add something, sorry, about the first question?
Yeah.
Or is someone willing to? Yes, just to talk a bit about what is an informed decision. So, of course, it is an ongoing case law. It's in building. But interestingly, the Article 14 is, we think, less prescriptive, but more detailed in terms of what you can expect of a meaningful intervention or informed decision. And I would say some non-deterministic, non-exhaustive criteria. You can have the fact that you have alternative information to confront. You have a specific level of expertise that allow you to compete with the output of the algorithm and not just accept passively. You do not experience any pressure or responsibility in terms of time or sanction, potential sanction if you answer something rather than something else. So I think there is a governance expertise elements that can help us understand a bit what should be actually a meaningful intervention. But it's a very difficult question. And you have, it's interesting because in the Article 14, you have a list of kind of criteria about the fact that you are aware of biases, you have the possibility to stop effectively the process, etc.
Yes, I see some more questions here and then there as well, here as well. Let's do the front guys first and then the ones in the middle.
Hi,
Yes.
Thank you for the very interesting panel. Topic that is very close to my heart. First of all, just Luca, you mentioned mostly it's courts making like interpretations on Article 22, but from the research I remember that it's mostly DPAs still. There are plenty of complaints and plenty of ex officio cases as well in which DPAs investigate. But this was back in 2022. Maybe things have changed. Now, you said you weren't going to touch on the digital omnibus, but I'm afraid I'm going to have to force you. Because, of course, it proposes the proposal changes to Article 22, a tiny change, which the Commission said is merely a clarification. So you can argue one way or the other. But my question to you is, if you were the ones proposing the legislation, what would you clarify or amend, alter the scope of Article 22 and the related provisions on access and information to make sure, you know, everything is protecting individuals in the way that it should be? Thank you.
That's nice, a wish list. And then maybe the question here at the front as well.
Thank you. Matthew Newman from MLEX. Just following up on the comments about the complaints, 300% increase in Norway, I think you said. And then you alluded to some complaints in the Netherlands. And then the use of AI as by the authority itself to respond to those complaints.
No, I don't think we said the response, the complainers.
Oh,
so
the complainers,
the
okay.
data subjects
But
using AI to create complaints. Yeah.
Okay. Well, I am aware that some data protection authorities are actually using AI to respond as well. So that's happening in Bavaria. Just if you could give a little bit more update and details about what's going on in the Netherlands. Thank you.
That's for us. Okay, shall we tackle the first question, our wish list? Do you have a wish list for what you would like to change on Article 22 if you were, you would have the option to?
Well, I think one tricky part of Article 22 is the solely automated part, right? Which not necessarily entirely matches the reality of how AI is used and the degree of human involvement, which makes it like a very high threshold to trigger that right in Article 22. So probably I would somehow massage the wording there to make sure that also maybe AI supported decision-making tools would somehow be part of Article 22. But I don't want to also give too many suggestions for reopening the GDPR, because we all know that it has taken a long time to reach certain compromises, and I think there's also quite a bit of room of not so much for changing the rules, but also to read the rules properly. The court is helping us. You pointed out to several DPAs also playing a role, and I didn't intend to diminish the role of DPAs for sure, but if we're talking about the big scheme of things and the level of practical use of AI, I don't think we have seen very many complaints compared to, let's say, the classic right of access complaints or other more, let's say, less tricky and more straightforward complaints that DPAs see all the time. I don't know if maybe you have news to share from the Netherlands, as was suggested by some of our audience.
Yeah, well, I can share some news from the Netherlands, but that mainly relates to guidelines adopted by the Dutch Supervisory Authority precisely on these topics we discussed today, so the right to explanation under the GDPR. I've read the guidelines, and obviously it's super helpful for controllers to have these guidelines, but then, meanwhile, I also ask myself, I had a look again at the guidelines of the Working Party, which are maybe somehow outdated now with the ruling in Dun & Bradstreet. So, yeah, I think what we should avoid is guidelines from every supervisory authority on how to actually implement the CJU's ruling. Perhaps that's a good point to actually reconsider, and whether there might be guidelines from the EDPB to operationalize the ruling of the Court of Justice. So this is the main update in the Netherlands, and the other cases are mostly cases in court related to Uber, and these are all in the public domain, and since 2 years or longer. So, yeah.
Yes, and you have until 26th of May to read the Dutch guidelines, the proposals for the guidelines. They've put them in consultation, so you can put them through an AI, for example, to read them in your own language and then comment on them. And you have until the 26th of May. I see. And they have a session tomorrow at 4, so by all means go to that one as well, so you can talk further on the topic as well. Are there any other questions? Yes, the two guys over there. Sorry, two men. Two persons.
Okay. Yeah. Can you hear me? Yeah. Well, in the context of providers that fine-tune existing GPA models rather than building them from scratch, would they only need to explain their modifications or also the underlying model? For example, what would happen, what would count as a sufficient explanation if I'm affected by a high-risk AI model system and the provider uses a fine-tuned version of DeepSeek or ChatGPT or Mistral? What would be a sufficient explanation, as the upstream models may have a black box, may not explain also the thinking of their models?
You mean the AI system, they're based on the models then?
Yeah, I mean, like dividing it in two, we would have the upstream model, like would be the GPA model, like ChatGPT, and then the provider would be someone using, fine-tuning that model to make an AI, a high-risk AI system. And in that case, what would be a sufficient explanation of to a user? Because maybe the output can change from model to model. Maybe I can fine-tune DeepSeek or Mistral and the output would be different, even though the fine-tuning or the database that I use is the same.
René Mailleux from Open University as well. My question is, you briefly alluded to the pre-GDPR nature of the right to an explanation and that it was barely used. I remember from my own research that at least in Germany, with regards to SCHUFA, actually, there was a lot of activity, as in many people and NGOs tried to get explanations about SCHUFA scores, and that was stopped first because the DPA didn't really want to enforce those requests, and then when it went to court, the court also gave a very restrictive interpretation on the right to an explanation. So there I'm like, I think people actually did try and were basically stopped by the interpretation. I wonder if some people on the panel know about other national, if the similar histories exist in other member states.
Yes, you're welcome to react on the second question first. It's
yes.
Fine.
Shortly on the first and shortly on the second. So on the first, I think your question embeds, it's a variation around the problem of black box I mentioned earlier and intrinsic limitations. I don't have a satisfying and definitive answer for this. I think the question of explainability when it turns to very big language models is a very big problem. That being said, downstream providers or providers by destination, they should know things, they should have documentations from the core provider of an AI model before integrating it into another system. So they are not completely blind to the conditions on where the models they embed has been trained and which data. But I completely agree with you. It will be a problem. And on the right to explanation, yes, we have this in France, in the French national law, Computer Science and Freedom, which is kind of a ancestor of the GDPR, I would say, Article 47. And which is completed by the code of relation between public and administration for transparency around administrative decisions.
Maybe I can say just a quick word on the history of Article 22 or the pre-existent right under the Data Protection Directive, which was actually inspired by the French rules. And so France is another good example where these rules also exist and people have tried to use them at some point. But it's also interesting that the directive was inspired by the French rules, with the difference that back then the idea was to introduced a significant difference. So under the French rules, it was a qualified prohibition, but in the directive, if you look at the legislative history, it was intended to make it a right to be exercised by the data subject. We know that now the Court of Justice has taken a different view, but it's kind of interesting that the court didn't look into the history of the provision when interpreting Article 22, because the wording, the key wording, at least in the first paragraph of Article 22, hasn't really changed from the directive. So one would have expected that that historical element of the directive would have survived, or at least be taken into account by the court today. But if you're looking into other countries to consider for your research, I would suggest that France should be a focus of yours, in addition to Germany, indeed.
Other questions, perhaps? Yeah, here in the front. No, not yet. I have to wait for the microphone.
Just two quick ones. So first one is, let me play the devil advocate here. So for a platform like TikTok, we have billions of users, right? We cannot possibly monitor and sort of moderate all the content that comes on our platform through human eyes. But then perhaps if I go back to work and I tell them that this was the conversation around AI moderation, then they will say that the AI model was actually trained and built on the data that the human fed to the AI, right? And I work in policy at TikTok, so the R&D team and the product team, they will come to me, they'll ask me for sort of give them the policy explanation with real life examples, and that's what I do. So what I'm trying to understand is that because the nature of the law wording itself is so vague, where exactly you draw the line between this is 100% AI moderation versus, okay, this is AI moderation, but there are human involvement as well. Because we have to have AI moderation. Like, there's no other way that we can moderate so much content that comes on the platform. But at the same time, I do appreciate that there has to be a fine line between when you actually define what is AI moderated versus what is human moderated. And I come with a very bona fide intention. Just to give you a context, like, I am an ex-human rights lawyer myself. So this is not to say that I'm against of what is being talked about, but just to bring in that perspective of like how businesses or big platform like TikTok, for example, we look at things.
Anyone specifically want to?
So I think I understood your point. So first of all, the automated qualification is not the only element of Article 22. You also have to have significant consequences on someone. And I don't think that all online moderation would qualify. It's an hypothesis. I don't know. There is no case law. But maybe not everything would qualify as a significant consequences. So this has to be completed in order to be qualified as Article 22. And for the rest, I think if you, on our view, if you qualified Article 22 automated decision, the intervention has to be individual. If you have a subset of people on which you do not intervene, and it has significant consequences, it should be a problem or illicit, except if you have an exception. So, yeah, that would be all.
Exactly. Any other questions from the room? There you go.
Thank you. So that was a very informative panel. I would like to ask you a question about the scope of the AI, the right under the AI Act, because it is, it is for the AI, high-risk AI systems under Annex 3, but I always think about what about other high-risk AI systems, because I work on especially medical, AI-based medical device systems, and to me, it's a very big problem that there is no such right applicable to the AI systems which are subject to sectoral rules such as medical device regulation. And I believe then we may see GDPR right as a backup there, but it is also not very useful always, because then when it is a sole automated decision or not, then I mean, for example, for the AI-based, for the AI-enabled clinical decision support systems, by definitions, they should be supporting the clinical decisions, but then, so it should not be a solely automated decision, the AI, the output, but then, so what right will be applicable in such a case? I mean, I cannot see a right under GDPR or AI Act. And I mean, I can give you this example from the field that I work very often, but it is not the only field. And I think this is a very big issue about the scope of these rights. And I think that is, yeah, I would like to hear the thoughts of the panelists, and I'll be happy. Thank you.
Yeah, I think it's a really good question. To be honest, I had a look at the legislative history of the right to explanation under the AI Act, and it was actually included quite late in the lawmaking process. So there is not much. But as I mentioned, this recital, like an adverse impact on fundamental rights, health, and safety, which would actually tie to your, let's say, use case, but the decision why only referring to high-risk systems under Annex 3, and even there with some exceptions, I don't know. And yeah, and then the only thing that would be left would be the GDPR, and then we have the discussion with whether it was solely automated or not.
I mean, maybe a complementary protection in a way under the GDPR is the transparency principle. You know, there is a principle that applies regardless of the sector we're talking about. So a certain degree of transparency would be expected anyway, even if strictly speaking, neither Article 86 of the AI Act or Article 22 or 15 would apply. I also think that the idea behind Annex 3 is also to have it as a, let's say, a living annex that could be changed over time if the Commission would realize that specific risk emerges. So that's also, I think, probably a way to deal with emerging risks. But I agree with you that on its face, if it's not in Article 3, then the AI Act would not, or the right to explanation under the AI Act would not be relevant.
Final question. Any final question? I think that means we can conclude this session, and I thank you very much for your attention. I point you to what was mentioned earlier, that tomorrow there's another panel where the Dutch DPA apparently is going to discuss their proposed guidance on Article 22 and the right to explanation. I'd like to thank all of the panelists here and abroad, and I wish you a very nice evening, and I'll see you at the drinks.